Thanks for joining us. I'm David Horrigan, eDiscovery Counsel and Legal Content Director at K-Cura. And I'm here at the University of Florida conference this morning with Gavin Manes of Avansic. Gavin, can you tell our viewers out there how you got involved in eDiscovery?
I was a college professor for several years teaching computer security, digital forensics at the University of Tulsa in Tulsa, Oklahoma. And there we built a forensics lab for cybercrime investigators. And the idea was if you paired a student who is bright, technology aware with a law enforcement officer, great detective but maybe doesn't have the technology, the two of them through some kind of osmosis would learn from each other. And the program then later became the CyberCore program, and it's a very successful program around the United States. We realized that the criminal forensics area was gaining some interest, and we decided to start a forensics company back in 2004 doing civil forensics. And then all of a sudden, 2 years later, we were told we're doing something called eDiscovery. And we were like, "Eda what? I don't know what you're talking about." No, the year is 2005, and now we're in the eDiscovery business, but just using forensics and scientific technologies to perform eDiscovery versus just some off-the-shelf software.
Gotcha. So is your business more cybersecurity or more eDiscovery these days? Or both?
We're definitely not a cybersecurity company. One of my colleague PhD students, he started a security company, and our constant joke is when he fails, I succeed, and his goal in life is to put me out of business.
Sure.
Because if he can secure the world and lawyers can write the contracts correctly, there will be no litigation and therefore no eDiscovery. Or if people stop using computers, there will be no eDiscovery. Those kinds of things might occur. But no, we're in the digital forensics. You used to work for me, now you work for someone else. What did you steal? Our most common case in the entire business. It's amazing how you can determine what people did. I mean, there's a lot of really crazy, nerdy words, shell bags, registry analysis that are performed on a regular basis. But then we do eDiscovery, which is taking the data that our clients possess and making it useful to lawyers and then potentially useful to some opposing party through traditional eDiscovery, processing, filtering, and review.
Sure. On what panel are you speaking today at the University of Florida EDRM conference?
I'm going to be talking on the panel dealing with email metadata. And so we're going to be talking about how can you use email metadata and analytics to determine how things can be put together in a more efficient manner. Why would you bother to review 20 emails that are part of an email thread when you can review 2 of the emails that are the complete picture of the entire email thread, and therefore saving, in that case, 18 documents that don't need to be reviewed by expensive attorneys.
Sure.
And other types of analytics.
You know, I was speaking with one of your co-panelists this morning, and Adam mentioned metadata in international settings. And I noted that, you know, we used to wipe metadata before we produce things because it's like, well, you don't have to produce it, so let's not. Do you still find that resistance into producing metadata, or do people just these days get it? They know that it's responsive, you got to produce it, and that's the end of the story.
Well, you have some very key decisions that occurred in the metadata field, and you also have an elevating opposing party. But right off the bat, you talk about something called PTO 16 or the DOJ production standard. Both include rather complex lists of metadata. Now, complex is 50 pieces of metadata, where maybe 22 of them are content derived. And what I mean by content derived is its file creation date, its original name, its creator author, not like the Bates label or the text or something we assign to it or its coding. And so you have some very common content derived metadata fields that are produced, to, from, subject, BCC, but then you have some ones that are extremely useful for analytics like conversation index and some other MapI fields. The easiest way to think about it, if you take a picture with your digital camera, there are actually 1,000 metadata fields that we can extract from that one picture. That's commonly called EXIF metadata. Everything from the aperture of the lens to were you standing a little leaning forward, a little leaning back, all that telemetric data is stored in the picture. And so in some cases, the right amount of metadata is key because you don't want to confuse someone or get someone lost in that trend, but having all that metadata as evidence is required under the rules.
You know, there's always been a push in the last several years to do eDiscovery natively. Don't move it into another platform, review the documents there, but it's been criticized, number one, because you can corrupt the data, and number two, for metadata concerns. In your eDiscovery productions and when you're doing review, do you find that most clients or most cases are doing it natively or some other way?
The word native is an interesting word that means something different to every person we talk to. A native production in some cases is in some electronic form, not being converted to some paper represented forms or 8.5 by 11. Yes, when we're going to trial and we're going in front of a judge, and when I serve as an expert witness, I have a printed, Bates labeled document that I give to the judge and I use in court. I don't use the native files in court because ultimately that jury is going to go behind closed doors and I can't throw a computer with a CD and say, here you go. My evidence needs to be concise. So knowing that our end format in some cases, if we go to trial, is going to be that 8.5 by 11 or some demonstrative board, reviewing in native is important because you're ultimately going to produce it, and it is significantly cheaper to produce that native form and review in that native form. But you said something else interesting. Why would I move a native document out of the place it's currently stored into something else to review it? And that's most likely just because the systems where we store data currently is today, don't allow for the external review or the external gathering of data. For instance, Microsoft Exchange 2012 and older, you wouldn't want to do doc review in it and you can't do production. But in 2016, they've added a doc review including some redaction features built into Exchange. A lot of fear for the e-discovery vendor business and the processing business because now we don't need to pull that data out of the corporation. We can just review it in place, look at it in place, and produce it in place. That's
a good point.
Of
course, with so many new and changing data sources, I'm thinking that we'll all still be in business because there'll be other places rather than email to get the data. But interesting stuff going out there. Thanks for taking the time to join us, and we'll look forward to your panel on metadata this afternoon.
Thank you.
Thank you for joining us.